I'd now like to introduce David Sager, who focuses on high-stakes litigation at Lowenstein Sandler. David is recognized for his expertise in franchise and distribution matters, where he represents many global brands. Today, David will discuss litigating post-closing claims for indemnification, breach, and fraud arising from stock and asset transactions, and how trial lawyers can team with deal attorneys to improve a client's position at the drafting stage. Please welcome David Sager.
So Tony alluded to the fact that you're not typically supposed to, or maybe not supposed to, open or close with a joke, but I think we all should be able to agree that you certainly should open with something from Spinal Tap. And for those of you who don't recall this scene from Spinal Tap, you should be ashamed, but the point I wanted to bring up here is it reminds me of a litigation matter. It was a stock deal between two large companies. They were represented by two big and terrific law firms, including one member firm that's here today. And in that case, the buyer bought post-closing claims against the seller. Just like in Spinal Tap, the litigation lasted 11 years. We never made it to trial, and the litigation lasted 11 years. And in fact, in the 20-odd years I've been doing this, I can't think of a time when I have not been defending a seller of a business, either in an asset or stock deal, from claims, post-closing claims. And what that raises in my mind is a basic question of why. Why, when you have big law firms doing terrific jobs, carefully drafting, similar provisions that are used over and over again, why do we have so much litigation? And that's the topic I want to address with you today. These are folks that are excellent lawyers. They've done scores of deals, and yet so many of those deals are prone to post-closing litigation. Why isn't a done deal done? Well, the reasons for the litigation, at least in my experience, are severalfold. Oftentimes, markets change. For instance, in the 11-year litigation I mentioned, the price of oil dropped precipitously immediately after the deal had closed. The deal was for oil and gas pipeline equipment. So we had a buyer that right from the start had paid, in their mind, a lot too much for a business. The second reason I've found that you see a lot of post-closing litigation is because personnel change. The executive who made a decision to proceed with a certain acquisition may no longer be there. Maybe that person is being second-guessed. So you have new people in the room who are rethinking the circumstances of the deal. A third reason is buyers learn more. And it's fairly common sense, but when you actually litigate one of these, you see it firsthand over and over. What happens when a buyer obtains a business or the assets relating to a business? Well, suddenly, they have all the documents, they have many of the employees, they have access to all of the information, and they have the ability to test the veracity of the due diligence that they had done leading up to the deal. Finally, the amounts at stake are often large. These are 9-figure deals, perhaps higher, and so the costs associated with thinking about a clawback relative to the price of the deal are not too high. These amounts, these factors, they cause businesses, typically buyers, to take a second look, a closer look. And the buyer asks itself, can I possibly claw back some of the amounts I spent on this transaction? And the buyer then has a financial incentive to hire lawyers, like all of us, to see whether they can justify some type of post-closing action. Can they get some of that money back? We as lawyers obviously are very good at finding loopholes in contracts, including ambiguities, and that includes very carefully drafted contracts. All contracts, I would suggest, have ambiguities, they have errors, and they have omissions. Of course, our corporate colleagues know this, and they draft for this. And that's why we have so many provisions, many of which we now consider boilerplate, in agreements. Integration, no reliance, waiver of reliance provisions. Perhaps the most common. These provisions typically say the agreement between the parties represents the entire agreement, and there are no representations outside of the four corners of this document. The corporate deals ordinarily have thresholds, deductibles, and caps. You can't sue until you've incurred a certain amount of damages, and you can't recover more than a certain amount of damages. Limitation of liability provisions, and then, of course, procedural tools. Procedural tools often are the most important. They're the most boilerplate and the most important. And the reason they are so important is because where we litigate and under what law we litigate is often outcome determinative. The law in this area is extremely variable, and knowing where you're going to litigate and what the law is in those jurisdictions is critical, as can be the decision to arbitrate as opposed to litigate. I handled a post-closing arbitration that lasted 6 years because we all know arbitration is very speedy and efficient. We had to abandon the arbitration because the arbitrators projected that the arbitration would need to involve approximately 200 to 300 hearing days. And there was a panel of 3. The arbitrators weren't doing anything wrong, but what it suggested was that arbitration was the last place the claimant in this instance should have been, because arbitration lacks something courts have, which is the ability to refine issues. So if you do include an arbitration provision in a deal, I would strongly encourage you to make sure that that deal has additional instructions as to how to make that arbitration streamlined. But does this mean, all these provisions I just talked about, that the deal is done? Well, of course not. Otherwise, I could end now. These provisions don't prevent litigation. The deal isn't done. Buyers bring claims. Most notably, or most typically, they bring claims for contractual indemnification. Most deals limit their remedy to contractual indemnification under the deal. They bring claims for misrepresentation, which fraud, concealment, and plaintiffs like fraud claims. Why? Because we have all these limitations that have been built into a deal. And those limitations pose a challenge as long as the contract is in effect. But if I, as a plaintiff, can figure out a way to avoid the limitations in the contract, the damages threshold that may be there no longer applies. The threshold I can't meet may not apply. And the remedies that may be available to me, including punitive damages, and the limitations on those remedies may not apply. So folks bring these claims, including securities law claims, in the context of stock deals, knowing much more about the market they're in. They think they've paid too much, and they look for ambiguity. So let's talk just briefly about parole evidence. Ambiguities, as I've mentioned, exist in even the most carefully drafted documents. And while it is absolutely true that the parole evidence rule is intended to prohibit the admission of evidence which contradicts or is intended to change the clear meaning of a contract, there are two very important exceptions. One, if you have an ambiguity, all bets are off. And two, if the allegation is that there is fraud, parole evidence is going to be admissible, or it's going to at least be considered by your finder of fact in constructing the deal. So parole evidence is not an in or out concept. Parole evidence may not be used to change the agreement, but it absolutely will be considered, and discovery of parole evidence will be considered as well. And that discovery is likely to include contemporaneous communications at the deal stage. And our corporate colleagues often have a business role. So query whether in that business role their communications are privileged. When you litigate these cases, the corporate back and forth and the corporate internal communications with the client and even within a law firm may not be protected and often provide a treasure trove for a claimant trying to reopen a deal. But I want to focus more on the fraud claims because that's where the debate, at least now and in my experience, is primarily focused. That's the battleground. Fraud claims can be based on alleged misrepresentations in the contract. The contract says something that is untrue. Outside the contract, there's an oral statement that is untrue, or it can be based on omissions and concealment. And again, part of the benefit of the fraud claim is that if there's fraud, the contractual protections and limitations are null and void. All of those carefully drafted provisions won't apply. Or will they? As we know, fraud claims require reasonable reliance. And this is the crux of the issue that's addressed in most deal litigation. How can I, as a seller, insulate my client from post-deal litigation based on misrepresentations? The way I can attempt to do that is by negating the element of reasonable reliance up front. So the question is, can careful drafting prevent a showing of reasonable reliance? The answer first came in a notable way, from New York State Court of Appeals in 1959, in the case of Dannon versus Harris. And in Dannon Realty, the court turned the question on its head. And what the court found was that, wait a minute, buyer, you're claiming that the seller lied to you, said something to you outside of the four corners of the document, and you're complaining. But what about what you said in the agreement to the seller? You told that seller when you signed that agreement that you didn't rely on anything outside the four corners of the contract. And remarkably, particularly given that this is 1959, the court said, you're the one that committed fraud, buyer. If you didn't rely on anything outside the contract, or I'm sorry, if you did rely, you shouldn't have said in the contract that you did not. Of course, the law is not that simple, and it's riddled with nuances. And the battleground states currently, as you might expect, are California, Delaware, New York, and Texas. In those states in particular, which tend to be more corporate friendly, depending on the governing law, depending on where you are, sellers can prevent fraud claims. Sellers can use provisions to insulate themselves from liability for a lie. That's fairly remarkable that the law has evolved to that point. If I lie to you as a seller outside of the four corners of the contract, but I have a carefully drafted provision in that contract, then I am insulated from liability, at least possibly, under the laws of many states. A general disclaimer is probably not enough, though. The law has held that it's not enough for me to say that this contract is the entire agreement between the parties and there have been no representations made outside. But if I take it a step further and I say the law is, this contract represents the agreement between the parties, and I have not told you anything about the profitability of this business before or after closing, other than is stated in this agreement, and you sue me later, and you hand me at that point, or you hand a court the document where I lied to you, and I in fact did lie to you. The courts have said it's too bad, because the specific disclaimer in the contract is sufficient to negate the element of reasonable reliance. The oral representation regarding profitability, depending on where, again, you're litigating, should be barred. Now, the same cannot be said for intentional misstatements in a contract, within the four corners of the agreement. If a representation is false in an agreement, as you might expect, And that representation is intentional. The no reliance and waiver provisions, even in a corporate-friendly or a seller-friendly state, likely will not apply. In 2007, a Delaware court looked at a case in which a party had agreed to a cap of 4% of the sale price, which worked out to $20 million. And the question before the court was whether that cap was enforceable in the context of a fraud claim. So seller wanted to enforce the cap and say, even if you can prevail or can sustain a claim, you can only get $20 million. Buyer said, no, there's fraud. And the court in that instance said, had this allegation, had this fraud occurred outside of the contract, we'd agree, because there can't be reasonable reliance. But if the fraud occurred within the confines of the contract, sorry, public policy is such that we cannot permit the lie to prevail. So the law recognizes the ability to insulate against a lie that is outside the contract, but not against a lie that is contained within the four corners of the contract. What about omissions? The answer, again, depends on where you're litigating or what law you've chosen in your deal, which I suggest is one of the critical points in any deal, one of the starting points. And the answer, again, depends on what you've done in your contract. Have you said, for instance, in your contract, that buyer, you have had a full and fair opportunity to look at each and every document we have. We've made every file room open to you. We've made every plant available for inspection. We've given you access to every employee, or at least every key employee. We have made it possible for you to verify everything we have told you in this agreement, every representation we have made, and you can avail yourself of that at your discretion. If we say that in an agreement, what that does is, again, it ups the bar for a buyer to complain about reasonable reliance. How can their reliance be reasonable if they had an opportunity to kick tires and didn't do so? So it's important at the drafting stage, whether it's an omission claim or a misrepresentation claim, to look at the provisions and see if they're specific enough to address your particular circumstance. The point of all this is we as litigators often deal with problems after they occur. In the 20-odd years I've been litigating these claims, one of the benefits of them is it actually gives you an opportunity to look at it from two perspectives. One, you can deal with your corporate colleagues at the outset and share with them your views on how these issues play out in litigation and how they can improve the language they're so used to using and use quite well. And two, by understanding the jurisdictions that are more favorable to corporations, you may have much more tools at your disposal than you may have thought. And maybe, perhaps, done deals will stay done. Thank you for listening. Enjoy the break.